Hello, my name is Chris Morales. I'm a criminal defense attorney in San Francisco, California. I'm a board-certified specialist in criminal law. Today I want to talk to you about your right to have a jury trial if you are accused of crimes, and when it is appropriate to waive your right to a jury trial. So, the Constitution says that every person who's accused of a crime in the United States has a right to a jury trial. What does that mean? That means that the prosecutor needs to bring evidence and testimony to a criminal court and present that in front of 12 members of the community who are chosen as jurors. Those jurors will listen to the evidence and then they will decide whether the defendant is guilty or not guilty. If they decide the defendant is guilty, it has to be a unanimous verdict. If only 11 jurors find that the defendant is guilty and one says no, that he's not guilty, then there is no conviction. And if they find somebody guilty of a crime, it has to be beyond a reasonable doubt. So it's a very high standard. There really can't be any questions as to the guilt. And so that's what happens when you choose to go to trial with a jury. Every once in a while, and it's very, very rare, you may want to waive your right to a jury trial and have your trial in front of a judge, one person. That's very rare, and I have found in my experience that only happens when the defense attorney lacks confidence in themselves and they don't have the requisite experience and they are somehow afraid of going and tackling a jury trial. So be very, very careful if your defense attorney recommends waiving your right to a jury trial. You should almost never do that. If you have any questions about this, about your constitutional right to have a jury trial, please feel free to call me at 415-552-1215. And be sure to follow the Morales Law Firm on LinkedIn, Facebook, and YouTube.